Welcome to Exposing the Truth in the Digital Evidence. Today we're taking a deep dive into the fascinating and often high-stakes world of computer forensics. Our mission today is really to equip you with the crucial skills needed to navigate the legal landscape as a digital forensics professional. This deep dive is particularly tailored for you, Dr. Sampak College of Business students, whether you're in our BBA, Management Information Systems, BAS in Information Technology, or BS in Computer Information Systems programs.
Especially those focusing on computer forensics.
Exactly.
Yeah.
But truly, if you're any college student or a working professional interested in how digital evidence actually stands up in court, this is for you. We'll be drawing insights directly from Chapter 15 of Guide to Computer Forensics and Investigations, 6th edition by Nelson and Stewart. It's really a foundational resource for mastering this field.
Yeah, think of this deep dive as your shortcut to understanding the essential realm of expert testimony in digital investigations. We're going to put ourselves in the shoes of Jamie, let's say, a promising digital forensics professional as they prepare for their very first high-stakes courtroom appearance.
Okay, I like that.
Right, and every piece of advice we uncover today will be crucial for Jamie's success, and, well, yours too.
So if you're ready to learn how to present digital truth in a courtroom, let's get started. And hey, if you find this deep dive valuable, please like, subscribe, follow, share, and comment. Your engagement truly helps us bring more crucial insights your way. Okay, let's unpack this crucial first step for Jamie. Understanding what testimony actually means in the digital forensics world, because not all witnesses are created equal in court, are they?
That's exactly right. And what's fascinating here is the clear distinction between two types of witnesses. It's really vital for Jamie to know which role they're stepping into. First, you have a fact witness. Their job is purely to present the evidence and explain what it is and how it was obtained. They just stick to the facts, offering no conclusions or opinions. Think of them saying, this is the data I found and this is how I got it. Purely factual.
Got it. Just the facts.
Then there's the expert witness. Now, this is often the role for digital forensics professionals like Jamie. An expert witness goes a significant step further. They offer opinions based on their specialized experience and the facts gathered during an investigation.
So they interpret.
Exactly. They interpret those facts through their unique knowledge. So Jamie, as an expert, would say something like, this is what I found, and here's what my expertise tells me it means for the case. This distinction is critical because, well, it dictates how you prepare and what you're even allowed to say.
So if Jamie is stepping into this pivotal expert role, how do they even begin to prepare beyond just knowing their forensic findings? It sounds like there's a much larger legal chess game at play here.
Oh, absolutely. Preparation is paramount, and it absolutely goes beyond just the technical findings. Jamie needs to consider some really critical questions that frame their entire testimony, like what's the client's overall theory of the case?
Okay, the big picture.
Right. This guides your focus. Make sure your findings actually support their legal strategy. Then, what's your story of the case from your perspective as the forensic professional? You need to articulate your findings as like a coherent narrative, not just a list of data points.
Makes sense.
A story. And what can you say with absolute confidence, backed by your evidence? This is about knowing your limitations and sticking to what's verifiable. How does your opinion fit into the broader theory being presented by the legal team? And crucially, what's the specific scope of the case?
Scope, right. Don't go too far.
Exactly. Have you gone too far in your analysis, or are you staying precisely within the requested parameters? These questions help Jamie and, help you approach the testimonies strategically.
Beyond just the mental preparation and understanding the case theory, there's the tangible work, preparing the actual digital evidence itself. Yeah. What are some of the absolute non-negotiables here to make sure your digital evidence is, well, ironclad and admissible in court?
Yeah, this is where the rubber meets the road, so to speak. Absolutely critical guidelines include documenting every single step you take. You have to prove repeatability.
Repeatability. Why is that so key?
Because the opposing side will try to challenge your methods. And if you can show your process is sound and, crucially, can be replicated, your credibility just soars.
Yep.
You also must validate your tools.
Validate the software you used.
Yep. And verify your evidence using well-established hash algorithms like MD5 or SHA-1. Think of a hash as a unique digital fingerprint for your data.
Like a fingerprint, okay.
If even one tiny bit of that data changes, the fingerprint changes completely. It provides irrefutable cryptographic proof that your evidence hasn't been altered from the moment you acquired it.
Wow, okay. Non-negotiable. What else?
Another non-negotiable is maintaining a strict chain of custody for all evidence. from collection right through to presentation.
Chain of custody. Heard that one before.
It means every person who has handled the evidence, when they handled it, and why. It's all meticulously recorded. Why? To prove that the evidence hasn't been tampered with and its integrity is preserved.
Makes sense.
And a key point often missed. Only collect the information specifically asked for, no more.
Really? Don't grab extra just in case.
No. Overcollecting can open you up to accusations of overreach or, fishing expeditions. Also, note the date and time of your forensic workstation when starting analysis establishes a clear timeline. And importantly, only keep successful output from your tools.
Only the successful runs.
Right. Don't document failed attempts unless they are somehow relevant to a specific challenge you faced. And when searching for keywords, use well-defined parameters so your search is defensible and thorough.
I heard a surprising tip about checklists, that it's advised not to use formal ones. That seems kind of counterintuitive, especially when good practice often emphasizes checklists for consistency. Why would not using a formal checklist actually strengthen your position in court?
It's a great question, and it really speaks to the nuances of legal strategy. You're right, it might seem counterintuitive, but it's advised not to use formal, rigid checklists because opposing attorneys can scrutinize every single checked or unchecked box. They can turn minor deviations into major attacks on your methodology.
Ah, I see. They can pick it apart.
Exactly. Instead, keep your notes simple. List only relevant evidence on your report. Crucially, define any procedures you use for analysis as scientific and conforming to your profession's standards. This emphasizes the rigor of your methodology without providing a specific checklist that can be nitpicked to death. It's about demonstrating adherence to principles rather than rigid checkboxes.
Got it. Principles over checkboxes. Okay. And what about Jamie's role beyond the courtroom, like as a consulting expert? There are practices they should follow even before being formally retained, right, to protect themselves in the case.
Absolutely. As a consulting expert, or even before being formally retained, there are key practices. For instance, do not record conversations or telephone calls.
Don't record. Why not? Seems like good record keeping.
Well, because these recordings can create unforeseen legal complications, they become discoverable records that might be used against you or your client in ways you didn't anticipate. If you're involved in federal cases, be prepared to provide a detailed history. Your preceding 4 years of experience, 10 years of any published writings, previous compensations for expert testimony.
That's a lot of background.
It's often standard disclosure. Always learn about all other people involved in the case and the basic points in dispute, gives you crucial context, helps you avoid conflicts, and consistently brief your attorney on your findings and opinions. Communication is key.
Okay. And a practical tip you mentioned.
Right. If you're approached for expert testimony, try to find out if you're the first one they asked. If not, understand why other experts might have been contacted but not retained. There might be a hidden reason, maybe a problem with the case or the evidence, and you should be aware of it. Helps you avoid potential pitfalls or understand the challenges ahead.
Okay, let's talk about building Jamie's professional identity through their CV. In this context, it's far more than just a job application, isn't it? What's its unique purpose in establishing credibility for expert testimony?
Exactly. Think of your curriculum vitae, CV, not just as a resume, but as your legal shield in a way. Its primary purpose in court is to list your education, training, professional experience, all to directly qualify your testimony.
Qualify you as the expert.
Precisely. This document establishes your credentials and expertise for the judge and jury. It shows why you are uniquely qualified to offer an expert opinion. Keeping this document updated and complete is crucial. Recommendations. Show continuous skill enhancement, demonstrate you stay current.
Keeps you sharp.
Detail specific accomplishments, list basic and advanced skills, and definitely include a testimony log.
A testimony log, what's that?
It's a record of the cases you've testified in previously. It's not just a list. It's proof of your consistent experience and successful track record. It makes it harder for opposing counsel to paint you as a novice or, a one-off expert. It subtly communicates, I've been here before. I know what I'm doing.
That's smart.
Yeah.
How often should it be updated?
You should update your CV at most every 3 months to ensure it's always current.
Okay. So it's your professional fingerprint for the legal system. What should Jamie definitely not put on their CV, even if it seems like it would demonstrate their vast knowledge?
This is a subtle but important trap. Don't include a separate list of books you've read in your area of expertise on your CV.
Really? Why not?
Shows you're well read. Because this might suggest you implicitly approve of everything written in those books. Opposing counsel could pick a controversial point from one of those books and try to force you to defend it during cross-examination. Creates unnecessary vulnerabilities. Stick to your own work and verifiable experience.
Got it. Avoid potential traps. Now, beyond the CV, clear communication is absolutely key. Forensic findings can be incredibly technical. Jamie needs to simplify these for a non-technical jury. What about preparing clear technical definitions for the courtroom?
Oh, it's absolutely essential. Jamie needs to prepare clear, concise technical definitions for any specialized terms they'll use before a trial. This ensures the jury, who likely have zero technical background, understands the testimony and isn't just lost in jargon.
Right, avoid the jargon fog.
Exactly. Jamie should be ready to explain terms like digital or computer forensics itself, how it differs from traditional investigations. They'll need to define hashing algorithms, MD5, SHA1, remember those unique digital fingerprints we talked about earlier.
The fingerprints, right.
They should also define image files and bitstream copies. An image file is essentially an exact sector-by-sector replica of a digital storage device, like a hard drive.
A snapshot in time.
Pretty much. Taken at a specific point in time. A bitstream copy is the most forensic type of image, a bit-for-bit duplicate of the original media, including all hidden or deleted data. Jamie should also explain a file slack and unallocated free space.
Okay, what are those again?
File slack is the unused space at the end of the last data cluster allocated to a file. It often contains fragments of previous data. Unallocated free space refers to areas on a drive that the OS marks as empty and available for new data, but which frequently still hold remnants of old deleted files that haven't been overwritten yet.
Ah, so hidden treasure troves for evidence.
Potentially, yes. These are crucial areas where hidden evidence often resides. Other terms to define clearly. File timestamps. Created, modified access times, computer log files, system records of activity, folder or directory, hardware, software, operating system. Jamie needs to break down complex concepts into digestible explanations. Analogies can really help here.
And in today's world, cases can blow up in the media. Legal actions draw attention. How should Jamie, or any forensic expert, deal with the news media when a case they're involved in becomes high profile?
The general recommendation is pretty clear. Strictly avoid contact with the news media.
Just avoid them completely.
Yes. It's a critical point that can protect the case and Jamie's credibility. Why? Well, your comments, even if well-intentioned or off the cuff, could inadvertently harm the case. They create a public record that can be used against you in court. Plus, you have zero control over the context of how a journalist publishes information.
A quote taken out of context could be bad.
Incredibly damaging, and you really can't rely on a journalist's promises of confidentiality. The risk is simply too high. Best let the legal team handle media communication.
Okay.
Yeah.
Steer clear. Now let's talk about the main event. Testifying in court. What are the general procedures involved in a trial that Jamie needs to be aware of? It's not just showing up and talking, is it?
No, definitely not. There's a structured process Jamie will encounter, usually 4 key procedures. First, your attorney presents you to the court as a competent expert or fact witness, basically laying the groundwork for your testimony.
Setting the stage.
Right. Second, the opposing attorney might then attempt to discredit you, maybe questioning your qualifications or methods. Third, your attorney guides you through your testimony that's direct examination, where you present your findings and opinions.
Your turn to shine.
Sort of. And finally, the opposing attorney conducts a cross-examination where they challenge your testimony and try to poke holes in it.
Before Jamie even gets to share findings, they have to be formally qualified as an expert by the court. What's that crucial process called again? And what's that savvy tip for their attorney during that phase?
That qualification phase is known as Voir. It's French, basically means to speak the truth. During this, your attorney asks you questions to establish your credentials, your expertise, your relevance to the case.
Proving you're the right person.
Exactly. And here's that useful tip for your attorney. If you happen to know that the opposing expert witness either taught or even just took a course using a publication you wrote or co-authored,
Oh, interesting.
let your attorney know. They can then emphasize that you're the author during voir dire, potentially strengthening your credibility and maybe even using it when questioning the opposing expert. It's a subtle but potentially powerful way to establish authority right off the bat.
Nice little strategic move. Okay, so once Jamie's on the stand, it's not just about knowing their stuff. It's about effectively communicating it, especially to a jury that might not understand the tech side. What are the general guidelines for testifying effectively?
Yeah, it really boils down to professionalism, clarity, and audience awareness. Be professional and polite at all times, obviously. Be conscious of the jury, the judge, the attorneys. You're communicating to all of them, but the jury is your primary audience.
Talk to the jury.
Right. If asked something beyond your expertise, respond clearly. Say, that is beyond the scope of my expertise, or I was not requested to investigate that. Why? Because guessing or overstating opinions can severely damage your credibility. Stick to what you know.
Don't speculate.
Never. Always acknowledge the jury. Direct your testimony to them. Use simple, direct language. Build repetition into your explanations. It helps with understanding and recall. Describe events chronologically if possible. It's easier for people to follow. If you have to use technical terms, identify and define them clearly for the jury. Cite the source of the evidence supporting your opinion.
Makes sense. And how you present yourself.
Dress appropriately for court, absolutely. And crucially, do not memorize your testimony.
Don't memorize. Why not? Seems like good preparation.
Because memorized testimony sounds unnatural, almost robotic. It can be easily tripped up under pressure, and frankly, it makes you seem less genuine, less credible. You need to know your material cold, but speak naturally.
Okay, know it, don't memorize it. What about visual aids? Graphics can be so powerful in explaining complex digital evidence, but are there specific rules for how they should be presented in court?
Absolutely. Graphical exhibits can be incredibly helpful. They illustrate and clarify your findings, making complex information accessible, but they must be clear, easy to understand, big, bold, and simple.
Keep it simple. KISS.
Exactly. The goal is to provide only the information the jury needs to know without overwhelming them with too much detail. Review all graphics with your attorney beforehand to ensure they align with the legal strategy. Make sure the jury can clearly see them.
Practical point.
And face the jury during your presentation. Maintain that eye contact. A couple of key don'ts. Don't include vendor logos on your charts.
Why no logos?
It can appear biased, like you're endorsing a product. And don't use charts created by someone else unless you specifically commissioned them. Using uncommissioned work can lead to copyright issues that could discredit your whole presentation and just reflects poorly on Jamie's professionalism.
Right. Stick to your own work or commissioned work. Beyond presentation, what are some common pitfalls or problems forensic experts like Jamie should look out for? Things to actively avoid during testimony that could undermine their credibility or the case itself?
Yeah, there are several critical traps to be aware of. First, recognize potential conflict of interest issues early on. Avoid agreeing to review a case unless you're under a formal contract that protects both you and your client. Avoid casual conversations with opposing attorneys outside of formal proceedings.
They're not your buddies here.
Definitely not in this context. Ensure you receive payment before testifying. Believe it or not, unresolved payment issues can become a major distraction and even a point of attack. Don't talk to anyone about the case during court recesses. Conduct all attorney conferences in private settings to maintain privilege and avoid accidental disclosures.
Okay, keep things tight.
And here's a really critical ethical obligation. It often gets overlooked but speaks volumes about integrity. If you find exculpatory evidence.
Exculpatory meaning it helps the defendant.
Exactly. Evidence that favors the defendant. You have a fundamental obligation to ensure it isn't concealed. Your first step. Report this evidence to the prosecutor handling the case, and document that communication meticulously.
Document everything.
Always. Why? Because your role is to uncover the truth, not just find evidence for one side. If that exculpatory information isn't disclosed to the defense attorney in a reasonable time, you have a further obligation. You might need to report it to the prosecutor's supervisor or even directly to the judge. It's about upholding justice, not just winning a case.
That's a huge responsibility.
Yeah.
Okay, let's delve specifically into direct examination again. What's the main goal there, and how does Jamie achieve it effectively?
Right, direct examination. Often considered the most important part because it's Jamie's chance to tell their story, present their findings without the immediate challenge from the other side. You're testifying on behalf of the attorney who hired you. The goal is clear, concise communication that educates the jury.
Educate the jury.
Yeah. Jamie needs to work closely with their attorney to get the language right. Be wary of the inclination to be too helpful, maybe providing information beyond what's directly asked.
Don't volunteer too much.
Right. Because this can open doors for cross-examination on topics you weren't fully prepared to discuss. Review the examination plan your attorney has prepared thoroughly. Provide a clear overview of your findings first, then use a systematic, easy-to-follow plan for describing your methods. Practice testifying, not memorizing, but practicing the flow. Use your own words naturally.
Be authentic.
Exactly. Present your background and qualifications clearly at the outset. Avoid vagueness. And remember, when using graphics, you're essentially instructing the jury on how you collected and analyzed the evidence. Make it understandable.
Okay, direct examination is Jamie's chance to tell her story.
Yeah.
But then comes cross-examination. That's where the opposing side tries to poke holes, discredit methods, introduce doubt. What tactics might an opposing attorney use, and how does Jamie navigate that while staying composed and credible?
Yes, cross-examination. This is where the legal sparring really begins. Jamie needs to continue to use their own words, but be mindful that certain words can have additional, maybe misleading meanings in a legal context. Be acutely aware of leading questions.
Leading questions.
Yeah.
The ones that suggest the answer.
Exactly. They often try to put words in your mouth or force a specific yes or no. And the cardinal rule, never guess if you don't have an answer. It's always, always better to state you don't know or that it's beyond your scope.
Why is guessing so bad?
Because a guess can be easily disproven, maybe later in the testimony or by other evidence, and it just destroys your credibility. Stick to the facts you know.
Okay. No guessing. What else?
Be prepared for challenging, pre-constructed questions like, did you use more than one tool? That often leads to follow-up questions designed to find inconsistencies between the tools or your process. Anticipate rapid-fire questions that are designed to fluster you.
Keep you off balance.
Right. Opposing attorneys might declare that you aren't answering the questions when you're simply trying to provide a necessary, nuanced response. Or they might ask several questions all packed into one that's called a compound question.
Compound question. What do you do then?
Politely ask them to break it down or rephrase. Say, could you ask those one at a time? They might also make speeches phrased as questions or directly try to put words in your mouth. Stay vigilant. Listen carefully to the exact question being asked.
So, under that kind of pressure, how does Jamie maintain composure? How do they avoid getting cornered or contradicting themselves?
Patience is absolutely key. Maintain eye contact with the jury. Remember, they are still watching you, assessing your credibility even under fire. Avoid strict yes or no answers if possible.
Why avoid yes or no? Seems direct.
Because they often don't allow for the necessary nuance or explanation, especially in complex fields like digital forensics. A simple yes or no can sometimes be misleading without context. I once saw an attorney use a simple yes answer to box an expert into a corner, completely twisting their nuanced findings. It really hammered home why those strict yes or no responses can be so dangerous. Qualify your answers if needed.
Qualify the answer. Okay.
Most jurisdictions now allow the judge and even jurors to ask questions, so be prepared for that too. The absolute key is to avoid feeling stressed and losing control of your narrative. Don't let them rattle you. And look, don't have unrealistically high self-expectations. Everyone makes mistakes, might misspeak slightly. The goal isn't flawless perfection, but clear, honest, and defensible testimony.
Right, defensible. Okay, beyond formal trials, digital forensics experts might also get involved in depositions or hearings. How do these differ from a full trial? What are their specific purposes?
Good question. A deposition differs significantly from a trial, primarily because there's no jury or judge present in the room, usually just attorneys, a court reporter, and you.
No judge or jury. So lower stakes?
Not necessarily lower stakes, but a different dynamic. It's typically an opportunity for the opposing attorney to preview your testimony before trial. It lets them gather information, assess your strengths and weaknesses as a witness, and lock down your story.
Lock down your story.
Yeah. There are two main types. A discovery deposition, where the opposing attorney sets it up and conducts both the direct and cross-examination equivalents. They're discovering information. Then there's a testimony preservation deposition. This is usually requested by your client, maybe to preserve your testimony in case of scheduling conflicts or health problems later. These are often videotaped in addition to being transcribed. They preserve your testimony for potential later use in court.
Okay, so depositions are kind of like a dress rehearsal, but without the main audience.
Yeah.
And the opposing team gets a sneak peek. What are the specific guidelines for testifying at a deposition? How can Jamie be effective and not inadvertently harm their client's case?
It's all about composure and precision, maybe even more so than trial sometimes, because there's no judge to intervene. Stay calm, relaxed, and confident. Maintain a professional demeanor throughout. Use the names of the attorneys when answering, keep eye contact with them, but don't get drawn into an argument or overly casual chat.
Stay formal.
Be assertive in your responses. State your facts and opinions clearly. It's important to remember that being deposed in a discovery deposition feels unnatural. You're being probed, not having a conversation. If you prepared a written report, know it inside and out because the opposing attorney will try to use it against you looking for inconsistencies.
Know your report cold.
Absolutely. If your attorney objects during the deposition, pause. Listen to the objection. Consider their intended direction before you answer. Give them time to make their record. And be prepared to spell any specialized or technical words you used at the end for the court reporter. They need an accurate transcript. Now, problems can definitely arise during depositions. It's best to discuss any potential issues with your attorney beforehand. Be prepared to defend yourself and your methods, just like in court. Avoid omitting information, even if it seems minor. When you get difficult questions that could jeopardize your client's case, pause before answering. That pause gives you time to think, and it gives your attorney time to object if necessary.
That pause is important.
Very. Avoid allowing the attorney to box you into a corner or lead you into contradictions. Excessively detailed, minute questions are often an attempt to make you contradict yourself later on record. Be professional and polite. Even when giving opinions about opposing experts, stick to the facts and methodologies. Remember, you can correct any minor errors you make during the deposition. Don't panic if you misspeak slightly, just correct it clearly for the record.
Good to know you can correct yourself.
And finally, understand this. Discovery deposition testimony often doesn't make it directly to the jury. However, it can be used later at trial to discredit you if your trial testimony deviates from what you said in the deposition. Consistency is key.
Okay, consistency between deposition and trial. What about hearings? Are they structured like mini trials or are they a different beast entirely?
Testifying at a hearing is generally pretty comparable to testifying at a trial, just often on a more limited scope or maybe before a different kind of body. A hearing could be before an administrative agency, maybe a legislative body, or in a court.
Different venue.
Right. Often, administrative or legislative hearings relate to events that eventually resulted in litigation, kind of like fact-finding missions. A judicial hearing, though, that's held in court. It's specifically to determine the admissibility of certain evidence before a trial begins. And crucially, there's no jury present in a judicial hearing. It's solely for the judge to make a ruling on the evidence.
Judge only. Got it. So we've covered the legal process, the types of testimony, how to conduct yourself. But ultimately, it all comes back to the digital evidence itself and your collection methods. How does Jamie prepare to defend their evidence collection methods in court, ensuring both the evidence's integrity and their own credibility?
Yeah, this is where Jamie's deep technical knowledge absolutely has to combine with those communication skills we've been talking about. To prepare for court testimony, Jamie must be ready to answer detailed questions about the specific steps they took. Like, how exactly did you extract those emails from the image of that computer? For those of you students in MIS or IT listening, understanding this level of detail isn't just about court cases, right? Well, it's about how every data retention policy you might set, every incident response plan you design, every cybersecurity measure your organization implements. Eventually, all of that might need to stand up to legal scrutiny. Your expertise in handling digital evidence directly impacts corporate liability, risk management, and trust.
Good point. Connects it back to the business side.
Definitely. So Jamie would need to explain not just that they recovered emails, but the intricate how, detailing the specific features of the computer, its operating system, Windows, Mac OS, Linux, whatever it was, how their specific forensic tool interacted with that software environment, and precisely how those email fragments were identified and reassembled from, say, an Outlook PST file, or a Thunderbird MBOX file, or maybe even carved from unallocated space.
Get into the weeds.
You have to be ready to. It's about demystifying the technical magic for the judge and jury. You do that by showing the scientific rigor and repeatable processes behind every single step. It's about explaining why your methods are sound, reliable, and adhere to professional standards in the field. Wow, we've covered a tremendous amount today. From understanding the nuances of fact versus expert testimony, all the way to the detailed preparation and courtroom strategies that are just essential for any digital forensics professional. The ability to really expose the truth from digital evidence hinges not just on technical skill, but on effective and credible communication in these legal settings.
Absolutely. This deep dive into expert testimony is truly critical for anyone stepping into the field of computer forensics, especially for you students building your careers in MIS and IT. Thank you so much for joining us on Exposing the Truth in the Digital Evidence. We hope you found this comprehensive overview as enlightening as we did. And to encourage continued learning, we'd love to hear from you. Considering everything we've discussed today, what aspect of preparing for or delivering expert testimony do you anticipate will be the most challenging for you personally, and why? Drop your thoughts in the comments below.
Yeah, your insights are valuable, and your questions definitely help us all learn and grow.
Absolutely. And please don't forget to like, subscribe, follow, share this deep dive with your peers, your colleagues, fellow students, and leave us that comment. Your support really helps us continue to produce content that truly helps you learn and succeed. Until next time, keep digging for the truth.